advance the slide once, Kristen, that would be wonderful. So this is just a disclaimer that we have to give, that we're providing an educational activity here, and that we're not engaged in providing any specific legal advice, and we're not establishing an attorney-client relationship by virtue of your attending this webinar. We can move on to the next slide, please. And Kristen, is this PowerPoint presentation going to be available to participants after the session? Do you know?
I believe so, yes.
Great, super. Okay, well, here's what I hope to accomplish over the course of the next 45 minutes is to, kind of reflect on, what are our objectives when we attack a situation such as an estate plan? What are we trying to achieve? It's always important to kind of develop that as, the target. And then within the estate planning effort, we focus in on, well, what are the particular issues and concerns that we're looking at with regard to a third-party supplemental needs trust? And that really is a cornerstone for much of the planning that we do with regard to planning for the future life of a family member with an intellectual developmental disability. I want to then kind of categorize, we touched on these a little bit in the keynote, which is the first party payback options. These kind of have different names depending on who's giving the presentation or who's writing your reading. And I really think it's important for people who are not lawyers, but who are really interested in learning about this area, to categorize in a particular fashion. Hopefully I'll be able to explain that to you when we get to that option. And then the next is trustee options. The trustee is the person who will be, managing the supplemental needs trust over the lifetime of a family member with a disability, and who's going to do it. And so I'll run through some of the pros and cons of a variety of options. And finally, I want to spend a little bit of time talking about trust advisory committees. I mentioned those during the keynote. Trust protectors, some housing related issues, conflict of interest, and some equal versus equitable analysis that I like people to begin to think about. So that's the roadmap. That's what we're hoping to accomplish in the next 40 minutes now or so. And hopefully we'll have some time for some chat or question and answer. So let's move to the next slide, if we can, Kristen.
Right.
So the estate planning objectives is, first, we want to keep ourselves out of probate court. And why do we want to do that? Well, probate court and state administration is public. It's also inconvenient and can be costly.
Cost and money.
There are more alternatives available now than they were when I started practicing.
You really love your father, which is so stupid.
I'm sorry. Can you hear me okay? Yeah, okay. So to minimize probate court involvement is not only at the time of death, but also through durable powers of attorney, healthcare proxy, and HIPAA releases, so that if a family member, and say a parent, loses capacity, we don't seek guardianship or conservatorship over them. Rather, what we're seeking is to use these alternatives like durable powers of attorney, healthcare proxies, and appointment of advocate. Next bullet, please. And so minimizing probate court administration also, minimizes the state administration costs, since we're not having to file inventories and accounts with the court. The other thing that I want you to, really appreciate is the fact that it's going to sound crazy, but Massachusetts is a really bad place to die from a tax perspective. We have something called a death tax, an estate tax. And what that means is that if you have over $1 million in assets at the time of your death, now that includes any term life insurance policies that you have, the death benefit of the term life insurance policies, your retirement, any cash in the bank, investments, the value of your home. If all of that goes over $1 million, before anybody in your family gets any money, the state gets the money first, which is an estate tax. That $1 million threshold is the lowest in the country. There's only 16 states in the country that have an estate tax. and we're the lowest, along with Oregon. I'm licensed to practice law in Florida as well as Rhode Island, and little Rhode Island has a higher threshold than Massachusetts, and of course, Florida has no estate tax. So that's one of the things that we do went through an estate planning process, is to try to eliminate or lower any type of tax or transfer tax that's imposed at the state or federal level. Next, please. So obviously, it kind of goes without saying, what we're trying to do is transfer property interest to the next generation. But doing that, we are also concerned about, well, are there specific issues beyond the need for special needs planning and perhaps the need for a special needs third-party trust? Are there things going on in the lives of other siblings? Are they going through a divorce? Are they not mature enough to handle money? All of the things that you worry about, if they receive money, we also can tailor specific strategies to help maximize their enjoyment of the property, but at the same time, not subjecting that property to perhaps other people outside of the family who may want to get their hands on the money. So it's just not a matter of transferring property interest to the next generations. It's also being thoughtful and intentional about how do we do that in a way that makes sense for each family. And look, I started practicing law 35 years ago, but my first job full-time after I left UMass Amherst was an outreach worker, working with families back in the late 70s, helping them get SSI, getting on SSI and Medicaid, and doing advocacy at special education. If you meet one family, you've just met one family, right? Everybody's different. So I approach my estate planning work in a very individualized fashion. So it's not a cookie cutter. So when we're thinking about transferring property to the next generation, I think it's important to look at every child, just not the individual with an intellectual developmental disability. Next bullet, please. And that relates to one of the things we're looking at is asset protection. We want to make sure that the money, the property, the resources of the family get to the family and not get jeopardized by any outside influences. Next slide, please. So if you juxtapose that and build on, okay, now we're looking at an individual with a family, an individual with disabilities within the family. The first bullet will talk about the objective of, we want to get government benefits. And that means services and supports through the Department of Development and Services. It might mean food stamps, it might mean fuel assistance, it might mean subsidized housing, it might mean eligibility for one of these, the One Care program, the various Medicaid waivers that are out there. And the unfortunate part about the way in which many services and supports have been established from a federal policy perspective is that it's only for poor people. Doesn't make sense, but there's some history around why that is, and it has to do with conservative versus progressive, red versus blue, basic policy differences regarding how government resources get allocated. And unfortunately, a lot of this is based on the poverty model that you need to establish in financial eligibility before you get those benefits. Things are slightly changing, maybe changing under President Biden. I hope so. A lot of people are advocating for some changes, fundamental changes in the safety net. But right now, we're working with the situation we have. We want to be able to maintain eligibility for government benefits. And that means making sure the assets are held in a way that doesn't take away the government benefits, but also how they're spent out of the trust is just as important. You can have the best possible special needs trust, a supplemental needs trust, but give out cash or do in-kind support and maintenance payments, and you're going to reduce those benefits. So it's trust establishment, making sure it's funded correctly and worded correctly, but it's also administering those as well. If you're interested, every year for the last 20 plus years, our practice group has been providing a administration of special needs trust seminar for family members who are named as trustees. Now, historically, until last year, we did that on a Saturday from 8:30 to about 1:30 on a Saturday, usually the first Saturday in November. But last year, we obviously couldn't do it because of COVID. So what we did do is I broke it up into 2-hour, 3 webinars, 2 hours each. And rather than have 100 people sit in a room getting this, we had over 350, 400 people attending every night. So if you want to subscribe to our website, just shoot me an email. I think my email is probably in the materials. You can get it offline at the Fletcher Tilton website. Tell me you want to be part of our mailing list, and I will put you on that mailing list so you can get the notices of when these webinars are happening. Next bullet, please. So again, it's juxtaposing the eligibility for government benefits when we're in fact disinheriting people from a eligibility perspective, but we don't want to live like a pauper, right? We want to have an enjoyable lifestyle, and that's where the letter of intent and the language in the trust speaks to promoting a desirable and enjoyable lifestyle. Next bullet, please. We also have to recognize that there are people who can seek to exploit individuals with disabilities. It's a sad part of what we deal with. There's a higher percentage of folks get victimized financially or otherwise if they have a disability. And so we set up a trust with adequate safeguards to keep our eyes both on the trustee as well as on the accounts. But we hold the money in trust so that the beneficiary doesn't have what's called the right of gimme, doesn't have right to withdraw part. So it's a discretionary right held within the trustee, perhaps overseen by the trust advisory committee. Next slide, please. Thanks. So part of what we go through in our analysis in developing a special needs plan is to really thoughtfully think about who are going to be making the decisions, and are they aware and are they consistent with the family values and the preferences of the family as well as the beneficiary. So that's our objectives. We want to maintain and promote government benefit eligibility. We want to promote a good lifestyle. We want to protect and safeguard, and we want to make sure that the decisions are made correctly and in the best interest and within the preferences of the beneficiary. Next slide, please. So the basic special needs, planning options that we have on one side, and let's just run through on the left side. You can start that. Run through 3 bullets down, please. Good. So here we have the third-party supplemental needs trust, and I'm just going to stay on this now, because this is the centerpiece of if you are planning to fund a trust when you die or when both parents die. This is what you're going to be funding. It's a common law trust. It typically is revocable at the time you're living, and then it becomes irrevocable normally at the time of the passing of both parents. It receives money from third parties. It can be the beneficiary of sometimes a second to die life insurance policy on both spouses or on one parent, and it receives an inheritance. So focus on this. Let's call it a third-party supplemental needs trust. And then we can go to the right side. So we can run down that there are 3 bullets.
Oops,
Okay.
sorry.
No, let's
I'll go back.
Yeah, don't worry. Oh, good. Thank you. This is perfect. So on the right side now, you've heard about the pooled first-party trust. Well, the first-party trust that BARC has, it's a pool trust on that second bullet. The third-party trust, it's a little complicated, but the third-party family trust is actually a common law trust on the left side, doesn't have a payback provision. So we have these self-settled trusts, these pool trusts, and the ABLE accounts. All of these are in a section 1396P, a D4A. And that's part of the Medicaid statutes tied to the Social Security Act, which says that we're going to hold some assets for the benefit of an individual who needs Medicaid, who needs these welfare-based programs, but We also want to recognize that we don't want to force them to spend all their money down. And we want to provide some degree of flexibility and access. So these have been developed over time as exceptions to convert what is otherwise a countable resource into a non-countable resource or an exempt resource. They're all from the same law, and they all have payback provisions. When the beneficiary dies, the trustee has to notify the the Division of Medical Assistance that in fact the beneficiary died and there's some money left. Send us a bill for what you have paid for over that person's life. And if there's any money left in this payback trust, the trustee has to pay it back to the Division of Medical Assistance. In contrast, there's no payback to the third party supplemental needs trust. That goes out to the remainder beneficiaries, usually the other kids in the family or some charity or whatever, the parent or the grantor of the trust creator of the third party trust delegated. So that's an important distinction between the one side, which is the third party supplemental needs trust, and the other side, which is the Medicaid payback planning option. The other aspect of this is that the Medicaid payback planning options have a very curtailed, it's broad, but not as broad as a curtailed discretionary spending requirements. So for instance, in a self-settled trust or an ABLE account, person can't give away the money, can't gift out. It has to be for their benefit, their exclusive benefit. And there are limitations. The self-settled trust and the pool trust has to be for the sole of primary benefit. The ABLE account has to be for disability-related expenses, whereas the third-party trust is very broad, very discretionary. So that's why the third-party special needs trust, supplemental needs trust, the common law trust is the preferred option. It's our go-to, it's our cornerstone, and we only use the Medicaid payback planning options when the need arises, And I'll get into a couple of those options in about 2 minutes, maybe about 5 minutes. So let's go to the next slide, please. So I've indicated some important elements, and we can go down 5 bullets, so we don't have to 2, 3, 4, 5. Great, thank you. So important element, again, this is the one over on the left, common law, our centerpiece, is that full discretion is given to the trustee. So you want to be able to talk about a person-centered plan or a letter of intent, and this is where a trust advisory committee is perfect because they can provide, they may not want to serve as trustee, they don't want the vesting, they don't want the responsibility because there is liability attached to being a trustee, but they want to be involved. And the grantor wants them to be involved. So here you're giving some direction to the full discretion that's given to the trustee. I said before, if a beneficiary has a right to pull out money, then the government's going to say, well, that's their money, right? So you can't give a right of withdrawal to a beneficiary in this type of trust. It has to be held back from them. Well, sometimes trustees want to quit, sometimes they die, sometimes they become disabled. So the grantor, the person who creates the trust creator, can appoint the successor. They can nominate a successor. So if John Doe is unable or unwilling or ceases to serve as the trustee, then Jane Doe can serve. And then if nobody is left, then sometimes you give the trustees the ability to appoint their own successors at some point in the future. And then if they don't, you have 2 choices. One is to go to the probate court. We don't really like that because we're never sure who the beneficiary, who the court's going to appoint. And if people do supplemental needs trust in our firm, we have our law firm appoint a trustee. And it might be somebody in the family who would be appropriate, or it might be somebody within our trust department who could serve as trustee and manage the trust for the benefit of the beneficiary. Spendthrift and creditor protection, what this all means is that if the beneficiary gets one of those complimentary Visa or MasterCards or gets swindled to sign a personal guarantee or a promissory note, whatever personal liability that the beneficiary has incurred is not a liability for the trust, so that the assets of the trust are safeguarded from somebody who might want to swindle or have somebody sign a legal document incurring financial liability. Not gonna be able to be successful with respect to the money that's held in the trust by the trustee. Because there's so much discretion, this is going to the last bullet, because there's so much discretion in these types of trusts, that it's important to have, some eyes on the action of the trustee. So people should give some thought to who gets the accountings. It might be a guardian, it might be a trust advisory committee. But some thought should go into that. So we can go to the next slide. So what good are these third-party trusts? What can they pay for? Well, we can run through the next 5 bullets and see that it adds color, it adds quality to a life. As trustee of many supplemental needs trusts, I authorize purchasing condominiums if there's enough money. I've authorized purchasing cars, paying for summer vacations, paying for maintenance and repair on homes, certainly, clothes, vacations, things of that nature. For those families who don't have anyone close by, well, we've also partnered with support brokers and some case managers, private case managers, to provide advocacy and oversight, or some planning activities as well. So that's maybe beyond the scope of our trust officers within the firm. We do have 3 trust officers, and if you watch them on a daily basis, they look more like care managers or social workers often than the traditional sort of green shaded trust officers you might think about working in a bank or something like that. So it's really to add a lot of the color. And if you think about it, the trust is replacing the parents' spending on behalf of their family member, of their son or daughter. So we sort of are a continuation of of how the family used the money. Okay. Next slide, please. So we can, the ABLE account, ABLE stands for Achieving a Better Life Experience, and we can go through these bullets. So what is an ABLE account? A little history. There were for years I chaired the Policy Positions Committee of the ARC of the United States, and I always attended, and it's coming up, I think next week after next, the Federal Disability Policy Seminar. And if you have never attended the Federal Disability Policy Seminar because you didn't want to go down to Washington, D.C. to attend it, now you can attend it virtually this year. And so if you haven't attended it, I would get on the ARC US website and check out the fee and see if it's interesting, because for many years, we would be tracking the Achieving a Better Life Experience Act. Finally went into effect several years back. But before that, it really started with I think, a group of parents who had adult children with Down syndrome. And they would look at their peers and say, well, a neurotypical kids had the 529 plans, and we could set up a spending plan that would grow tax-free, and they would be able to use it for education. Why can't we do something like this for folks with disabilities? And again, it's rubbing up against that poverty mentality mandate of the federal, policy objectives. So the ABLE Act went into effect basically to amend that section 1396P D4A, which is the Medicaid payback. So it added the ABLE Act to say, okay, now you can put money into an account that's not going to be a resource. And then they created a law called section 529A under the Internal Revenue Service Code that allows for money that's put in this that becomes exempt and grow tax-free. And the distributions also are tax-free so long as they're for qualified disability-related expenses, which are listed on the last bullet. So right now, you can have one ABLE account for a person who's been determined to be disabled prior to age 26. And you can put it into up to $15,000, $15,000 annually. That's it. And if the individual has earnings, they're also able to add a portion. I think it's up to $13,000 or $14,000 of their earnings also into an ABLE account. That account could grow up to $100,000 without losing their SSI. If they go over the $100,000, that's going to take a long time, considering it's $15,000 a year, right? So it's kind of like a theoretical, unless you have really good stocks. But, 15,000 a year is going to take a long time. If you go over the 100,000, it's SSI suspended. It's not lost. So you just report that your account's gone under 100 and your SSI is reinstated. Medicaid or Mass Health eligibility is lost once you go over 500,000, but I have not seen anyone come really close to this. These are usually liquidation accounts where money goes in and money goes out. There is the annual contribution of 15,000, as I say, with additional contributions from earnings of the account owner. I think that I've covered that. I would just say to you that in Massachusetts, the ABLE Act accounts are exclusively handled through Fidelity Investments. And it's called the Massachusetts Sustainable Savings Plan. So if you Google, get on Fidelity, get on the Fidelity website and Google ABLE or Google Massachusetts Sustainable Savings Plan, you'll find a lot more information. There's also an ABLE National Resource Center that you can just Google ABLE National Resource Center. What do we have to do before Google, by the way? And you can get onto that web site and learn a lot more. And states have different types of programs, but Massachusetts is only with Fidelity. Okay. One other thing about the ABLE Act, you can get a debit card and actually use the money in the debit card. It's pretty user friendly. Next slide, please. So here we go. We can go through the control over spending. We can go through the 5 bullets that are here. This gets a little technical, but you can do the Transfer of Minors Act. One of the cool things about this, for those of you who are on SSI, or you maybe a rep payee for someone who's on SSI, that's a pain in the neck with regard to the 1/3 reduction if you pay for housing-related expenses. The way to get around that is to fund an ABLE account and then take the ABLE account and pay for rent or pay for food or other occupancy expenses, and then report back to the Social Security Administration that there's no longer that in-kind support and maintenance payment being done by a third party, but rather the occupancy expenses are now being paid by an ABLE account. They're going to up the 1/3 reduction, so to get closer to the federal maximum of a little over $700. Okay, next slide, please. I'm also mindful of the time. So we can go through the uses of these payback options. There are 4 of them. When I talk about the self-settled trusts, these are the D4A trusts or the first-party pool trust that BARC has. And so the first-party trust, it's called the D4A or over 93 trust. It has interesting uses. First is, as I said, there's no maximum asset limit, but there's also a confluence, like a perfect storm between elder law planning, okay, and special needs planning. So if a parent or a grandparent is going into a nursing facility and they're looking at, they've got a house, they've got $100,000 or $50,000, and they don't want to spend all that money on private nursing home care because the nursing home costs are going to take the house and the money. They could maybe private pay to get into a residential setting, a skilled nursing care facility, but then transfer the bulk of their assets into a self-settled trust. There's no period of disqualification. Okay, there's no look back period for the benefit of a son or a grandson. And so this is something that we use an awful lot in our practice because we have a very vibrant elder law practice group and a huge special needs practice group. So many of our clients, they have older relatives who are heading into a nursing facility rather than do the traditional Medicaid planning, which is the 5-year look back, into an irrevocable income only trust to protect the house and other assets. We can use this Ober trust as a backup as well. And it's proved to be a tremendous solution for difficult situations that families face when a loved one needs to go into a nursing home. The other aspect of a D4A trust is for those of you who may be receiving child support, that child support payments to you as the custodial parent will be considered income by Social Security Administration for purposes of eligibility for supplemental security income. And so what we do under the program operational manual system is kind of granular under the Social Security Administration is you can irrevocably have those child support payments assigned into a Medicaid payback trust, and that child support again as unearned income. So you're able to then keep your SSI eligibility. Otherwise, most child support payments, if they're being made, will greatly reduce or even disqualify a person from SSI. And so we do this on a regular basis and work with a lot of family law attorneys to make sure that this gets worked into separation agreements, settlement agreements, and also go back and a complaint for modification if a person has gone through a divorce. Well, we can go back on a complaint for modification, usually with the assent of both sides, because the child support payments aren't going to vary. It's just maximizing the benefit for the individual who's on SSI. And also, these are great for folks like Bart. They're always there as a great place to, when all else fails and no family members around, Bart does a great job managing these trusts. So next slide, please.
And just to let you know, we have about 10 minutes left.
Okay. We only have 2 slides, so that's good.
Perfect.
So when we work through who's going to run one of these trusts, we have 5 bullets. Let me dismiss banks and trust companies. They do great for many people, but I have not been impressed. And I'm quoting, and I'm happy to repeat this to any bank trust officer, but I've not been impressed by trust officers being able to understand the complexity of managing a supplemental needs trust. They're fine with investing, they're fine with doing their accountings, but in terms of understanding the ebbs and flows of a person's life with a developmental or intellectual disability, understanding financial eligibility for Medicaid or Section 8 housing or all the other complexities that we face in this area, unless you're in a desert somewhere where there's nobody else to be a trustee, I guess the banks and trust companies. So one good thing about them is that they're very efficient with regard to their investments. They're very careful with regard to how they account for things, but they're very bureaucratic when it comes to discretionary decisions. They usually have to make everything by committee over a certain amount of money, and it's just very time consuming, and it's not practical for a lot of folks. Professional advisors. So folks like me, folks like Fletcher Tilton, lawyers, some accountants, some wealth managers have fiduciary functions, and they can serve as trustees. Depending on their background, this option can be helpful. They get paid for their services. there's usually a succession plan. The disadvantage is that you want to make sure that they are aware of the complexities of special needs planning, that they understand government benefits, and that they will be respectful of the family values, since these trusts are highly discretionary. There are nonprofit corporations, which I recommend to many people, like Bart, to serve as trustees. The advantage is that they're nonprofit, they're mission driven. There's no threat of anybody dying, therefore they're going to continue, and they usually have a history with families. On the other side, they get paid, and the disadvantage is they get paid, as all of these, except perhaps a family member. Sometimes they're entitled to, family members are entitled to get paid. Most nonprofits partner with a bank or a wealth manager so that their fiduciary obligations are available. Then there's siblings and family members and individuals, which it's the last bullet, but frankly, most of my clients, that's where they go first, is they look for family members who are willing to serve as trustee, and they like that idea. I'm going to instill one option here, which is co-trustee option. And one of the options that you can have multiple family members serve as co-trustee. What a lot of folks have been attracted to is doing a professional trustee with a family trustee. So you get the family trustee acting with the heart, sort of knowing the family history, especially obviously a good relationship with the beneficiary. Then you've got a professional trustee managing from the head and doing a lot of the stuff that the family just doesn't really want to do. That might be filing the tax returns, making investments, modifying the portfolio, filing accounts, et cetera, and just paying bills, doing the kind of the grunt work of making sure bills are being paid. So we can go to the final slide, and hopefully we'll have a minute for a couple questions. First is the first special consideration, Trust Advisory Committee. Excuse me. Not a good time to lose my voice. The Trust Advisory Committee, I think we've talked about it. And if anybody has any specific questions, they can always reach out to me by email. I'm happy to have an email chat or a phone call. But these have become very popular if you have the resources. Now, there's that one question, but if I have a single mom and I don't have a single parent, I don't have a lot of resources, it takes a lot of groundwork to build one. The Trust Protector is a special office where the Trust Protector can fire a trustee and replace it. So it might be someone in the family who's just kind of keeping an eye on things and to keep the trustee honest. Next slide, please. One thing the parents should be aware of is that because there's so much discretion given to a trustee and a third-party supplemental needs trust, and the remainder beneficiary is oftentimes a sibling or a family member, the more money that's spent by the trustee is less money going out to the remainder beneficiary. So there's an inherent conflict of interest. Not every conflict can be avoided, but just be aware of that and kind of be intuitively know whether or not that's an area of concern for your family. The next slide relates to the fact that the special needs beneficiary, the supplemental needs beneficiary, typically does not have the ability to engage in gainful employment, whereas other family members do. So we have a discussion regarding, do we do an equal share at the time of death of the parents, or we do an equitable share? And that's just a really long discussion, or a deep discussion that you want to have among family members. I certainly almost always raise this as an option. But if we're going to do that, as I mentioned in my keynote, I think it's important to be transparent and not surprise people with regard to those decisions, but really involve this as a family conversation. Next is housing. We do a housing seminar, and we use these third-party trusts as owners of property. We integrate Section 8 vouchers to ensure that through the Americans with Disabilities Act, that beneficiaries who get a Section 8 voucher have a reasonable accommodation right. to have a friendly or adaptive landlord, which can be their parents, a family member, or a supplemental needs trust. And we get into this housing seminar, housing issues in great depth in our housing seminar, but just realize that it's just not about investments. It also can be a place to live. And then finally, on gifts from extended family members. Often people want to be able to give, and we create and recommend an irrevocable gift supplemental needs trust that be created with a separate tax identification number that can be managed by the parents and then by the successor trustees during the lifetime, and try to avoid gifts outright to a beneficiary or family member with a disability, but just get it into a gift trust, irrevocable gift trust. I apologize for talking fast. I think I'm just about reached the hour, 45-minute. So I did it, but I'm happy to answer any questions. But I think we're getting called back from Sonia.
Yes.
What time?
I was gonna say, I will see, there is one thing in the chat here. From Bill Smith, was wondering if you can have both an ABLE account and a first or third party trust, and can you transfer funds from the trust to the ABLE account?
You can transfer funds from a first party trust to an ABLE account, but you can't transfer funds from a third party trust to one of those, or vice versa. So third party trusts only take assets from a third party, can't be from the individual, but the first party trust can take assets from the individual. There has to be a very clear line of demarcation. Third party trust just from extended family members and parents, third parties. First party income from that's considered owned, or there's an equitable interest like child support that's attributed to the beneficiary. Okay.
Great. All right, so I think we are going to be going back to the main group for raffle prizes. Thank you so much, Fred. This was really great.
My pleasure.
Thank you, Fred.